Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Well, good afternoon, everyone, and welcome to another FIA Group podcast. Does this series even have a name? I'm not even sure, but that's okay. It's a FIA Group podcast, and so, we strive to bring value and a little bit of entertainment, although I'm not sure how entertaining I'm going to be able to be today based on the topic we're talking about. But before we get into that, my name is Chris Aguiar. I'm a Vice President and Subrogation Counsel here with the FIA Group, and with me today is Cindy Merrell. Out in Louisiana. You're not in Louisiana, Cindy. You're in Louisville. You want to introduce yourself?
Yeah, one of those L states. Yeah, no, this is Cindy Merrell. I am an attorney with the FIA Group. I do subrogation and reimbursement all day, every day. And I'm so happy to be here today.
Cindy, if someone had told you when you were growing up that you were going to be a subrogation attorney, what would you say?
I would first say, what is subrogation? And that sounds awful, but it's actually a lot more fun than you would imagine.
Oh, that's funny. I wanted to be an NBA basketball player, so I'm about, 6 inches too small vertically and maybe 12 inches too big horizontally to qualify for the NBA. So
it's a better dream. It's subrogation.
Amen, right? So today, we wanted to touch upon an issue that, has kind of always been an issue in sort of subrogation and more broadly sort of ERISA benefit plan administration, but has seen a bit of an uptick as of late. I don't know if plaintiff lawyers went to a conference and they all kind of were given a spiel, or if they're getting a little more sophisticated and or tactical in their approaches. But today we're going to talk a little bit about ERISA Section 1024B4, which is the provision in ERISA that effectively allows a plan participant at any time for any reason or no reason at all to request, every document under the sun, ever utilized at any time to establish or administer the plan. Now, that is not the technical language. I am paraphrasing a bit, if maybe not editorializing a bit as well. It is a problematic statute because, again, I described it as allows a plan participant to ask for every document ever utilized or established at any time that could bear in any way on the establishment or administration of the plan. Anyone that operates within these plans knows that is a lot of documents. And there's some interesting problems that come up when those requests are made, specifically and especially within the context of a subrogation reimbursement claim. You want to kind of talk us through the nuances here, Cindy?
Sure. So the whole point of this originally, we all know that ERISA was created essentially for the benefit of the employees. And this statute sounds good in theory that an employee can say, well, I want to know more information about my plan. And the statute itself states this is what the plan within 30 days of written request to the plan administrator must produce. It is a summary plan description, the latest annual report, any terminal report, the bargaining agreement, the trust agreement, contract, and this is the issue, other instruments under which the plan is established and operated. And we all know that that can be very broad. And right now, that phrase has a lot of litigation out there. And unfortunately, it's not very consistent across the country. And courts interpret that differently. What does that actually mean? And it's not been clearly decided what that means. So that's a little bit problematic for us. And if the plan does not produce the requested documents, there is at the court's discretion. So that means it's not an automatic fine or anything like that, but the court could impose a penalty against the plan of up to $110 per day. Now, I have not personally experienced with that occurring, It's kind of one of those doom and gloom, but it does happen. It can happen, and it's a threat that's out there for plans. So how that plays in for us is a lot of these plaintiffs' counsel are not that well versed in the ERISA statute, and they go to a CLE, which is called a continuing legal education, for an hour, and they think that they are coming out with the tools. Unfortunately, they have just enough knowledge to make them dangerous. And what's happened is they are sending these document requests, requesting all these things that they don't even know what they're requesting to us on the subrogation side. And when we are trying to subrogate and pursue reimbursement in personal injury matters on behalf of the plans.
Yeah, so Cindy hit the nail right on the head when she described it as very vague. And right, vague statutes are sort of a playpen for lawyers, right? And so I like to say, they come out of these CLEs or these conferences, they're either very sophisticated or not. And the truth is, we don't really have a good way of telling which one it is, because from an advisor's perspective, remember, we described it as very vague. And what that means is it's virtually impossible for us to know what a court might do. And then, of course, every court is different. Every judge is different. So in the absence of clear guidance, it can be very difficult for us to advise a plan administrator what exactly their response should be. And here's the other kick, is that, statutorily, the statute specifically requires the request to be made upon the plan administrator and the request to be responded to by the plan administrator. There's a lot of opportunity for a lawyer trying to kind of run interference, create hurdles. And this is especially true on the smaller dollar cases, right? You've got a case for, let's say, $5,000, $10,000 is the lien amount. It's very easy for a lawyer to send a demand to the plan. The plan gets it. Maybe they respond to it. Maybe they don't respond to it. Maybe they respond, but they don't respond with, quote unquote, every document, because maybe they don't have access to every document, or maybe they do, but they don't even really know what the appropriate response is in order to be in kind of full compliance. It creates this door, right? The lawyer then kind of sits on his hands and says, with an abacus, and starts counting the days. 1 day, $100, 2 days, $200. And then after several months, he reaches out and he says, oh, look, I demanded this. You didn't get me a response within 30 days. It's now been 100 days since my demand, and you now owe me $10,000. You'll recall we're only 3 months out from his demand, and the lien was only $10,000. So now arguably the fines are just as much as the lien. So it becomes quite a quandary for us to sit here with the benefit plans and say, well, I don't know what a court's going to do. Court may look at your non-response and say, shame on you, plan, why didn't you respond? Or maybe you did send an SPD in a Form 5500. A court in that case might say, well, you did try to be responsive, so maybe they're not going to assess all the penalties. The point is, there's so much variability that it's very, very difficult for even us to tell anyone exactly what they need to do in the face of that demand. What we do know for a fact is the plans need to respond, because no response is much more likely to engender a penalty, because a court will say, well, the statute says you need to respond and you didn't even try to respond. The other issue that comes into play is the concept of agency, and whether that demand comes in either to the plan or directly to the FIA group. Does the statute allow us to respond? If I provide, let's say, a Form 5500 and an SPD were sufficient, let's say those are the only documents the plan had, would those documents be sufficient coming from the FIA group? And the answer is, we don't know. Technically, under the statute, the answer would be no. And so there's all kinds of gray here that makes it really difficult to comply and or know exactly what sufficient compliance is. And so it's really important that plans kind of be on the lookout. And look, in the ERISA game, the reality is the law has been, suffice to say, overwhelmingly in plans' favor, Montanil notwithstanding. But we already kind of knew that the law was what Montanil said it was. So the point is, all the Supreme Court cases have come out pretty favorably for the plans. And so you get to this point where the lawyers are looking for any hook And this is a good one. It's a very, very, very intriguing tactic. It's a very effective one on, your $1,000, $3,000, $5,000, $10,000 liens. And any plan that's sizable, any TPA knows that the vast majority of third-party recovery cases do fall in that 0 to 25,000, 30,000 range. The amount of cases that are either above that or, more importantly, have the available limits to support that kind of recovery are very few and far between. So on those small dollar cases, it is a very compelling tool that a sophisticated lawyer could use to say, haha, I sent you this demand and you never responded. Cindy, what does the statute say, and is it kind of enveloped in that catch-all language? Stop loss contract, ASAs, PPO networks. What does the statute have to say about that?
So right now, there's not a solid, consistent policy across the circuits. However, for the majority of the circuits, stop loss contract wouldn't, and is a policy of insurance, and I would not anticipate that would be something that the plan would need to disclose that contract. Now, they may have to disclose, obviously, that they have stop loss.
Right, yeah, and it's important to understand, folks, that everything we're talking about, whether we say right now it probably needs to be produced versus probably not, again, we don't know exactly, but more importantly, it will definitely need to be produced should a case proceed to, let's say, litigation and discovery. All of that information will come out during discovery. I simply make the statement that, if you have the document and you are inclined to produce it, it may not be the worst idea if you're looking for, full compliance or to be able to say to a court, hey, I did the best I could to provide everything you've got. However, we also know that lawyers like to try to use stop loss as a smoking gun that kills all benefit plans' rights. So, certainly stop loss contracts, third-party contracts, I agree that perhaps in those instances, because they don't actually have anything to do with the establishment or administration of the benefit claims, the claims themselves are probably not as responsive. I do know that there's some case law out there that specifically says ASAs are not required to be produced, which is hilarious because anyone that's read an ASA knows it's one of my favorite documents to determine a plan's funding status, because it's very clear in the ASA where TPA is to go get the money. If anyone that's listening to this does know what an ASA is, it's Administrative Services Agreement. It's the agreement that the TPAs enter into with the benefit plans. And so, there's certainly precedent for this notion that the contracts the plan enters into may not be up for discussion here. But, again, we don't really know because there's not a ton of guidance on the issue, which I guess is good for us lawyers, right, Cindy?
Yeah. Well, I think that the overall impression that I have is that as soon as a plan receives one of these requests, and the attorney requesting it is typically the attorney, sometimes an employee, I guess, but for purposes typically of subrogation, we receive them from the attorney. And what they're looking for, whenever the plan gets that should set a clock for you guys for the plans. And the plan should do everything possible within those 30 days to get what they can to respond to those requests. I would rather have that information out there than not.
Yeah, to Cindy's point, it's not a lawsuit, but it is a issue that could significantly impact your right. And I'm always so baffled by the amount of clients that get served with a lawsuit and do nothing with it. This is another one of those. Whenever you're getting a demand from a lawyer, and I'm not saying a demand from a lawyer is tantamount to a lawsuit by any stretch of the imagination, but whenever you get a demand for a lawyer with a deadline, something should go off in your head that you're at least thinking, I need to go figure out if I need to comply with this. If you hadn't heard it yet, you heard it here first. When you get a letter requesting documents under the plan subject to ERISA 1024B4 or U.S.C, I don't know what the U.S.C citation is, but make sure you respond or at least reach out to us and say, hey, what the heck is this and what do I need to do? We won't be able to tell you with absolute certainty, but we'll certainly be able to give you some guidance as to what you should try to produce, what you have, and by when. And just remember that keeping good records for the plan for the entire time that the plan exists is important because, let's say it's plan year 2021. If the plan's been self-funded since 2010, while a 2010 document may not have anything to do with the situation at hand, it may. and the courts, the lawyers, the plan participants, if you will, won't know unless they see it. So they will likely demand that it be produced. And if you fail to produce it, it's plausible that could cause problems.
Well, thank you so much, Chris, for joining me today and having this conversation. I hope that with the holidays and everything, that nobody gets hit with one of these being such a busy time of year. But if you do, don't fret. Just get what you can and respond out as soon as you can.
And also remember, anytime these requests come in, they don't say business days. They say days, folks. So keep in mind, while you're having some Christmas cheer, that's a day that's being counted as it relates to 1024B4.
All right. Thank you, everyone.
Thank you so much, Cindy. Great to talk to you. I'm looking forward to seeing you later this week, and have a great day.